expansion.
Are you willing to acknowledge that the Administrative Procedure Act is a limitation on the Secretary's ability to cut off all the funds? She can't do it if that would be unreasonable. Are you willing to accept that? I wouldn't if I were you.
So what I'm trying to do here is to suggest that the Secretary does have discretion under the statute, and that
Indeed, not part of the discretion is to cut off all of the funds. That's what the statute says.
And it is possible, and I'm not willing to give that away. But that doesn't make this.
But General Verrilli, you're not willing to give away whether the APA would bar that. But the APA surely has to apply to a discretionary act of the Secretary.
I agree with that, Justice Kagan. But
what's making you reluctant?
I'm not trying to be reluctant. I understand how this works. I'm trying to be careful about the authority of the Secretary of Health and Human Services and how it will apply in the future.
I wouldn't worry a lot if I were you. I don't know of any case that where the Secretary's discretion explicitly includes a certain act. We have held that nevertheless that act cannot be performed unless we think it reasonable. I don't know any case like that. Yes, when there's just a general grant of discretion, it has to be exercised reasonably. But maybe Justice Breyer knows such a case. All right, give it to me.
So, if I could go back to this sheer size idea, there's I think another couple of points that are important in thinking about whether that's a principle courts could ever apply. Once you get into that business, in addition to the problem I identified earlier, that it basically means that Congress is frozen in place now based on the size of the program, you've got this additional issue of having to make a judgment about in what circumstances will the loss of the federal funding be so significant that you would count it as
I suppose one test could be, I just don't see that it would be very workable, is whether or not it's so big that accountability is lost, that it is not clear to the citizen that the state or the federal government is administering the program, even though it's a state administrator.
Well, but I think this is going to come from
unworkable.
This is going to come from a withdrawal situation. Their arguments about it's what you stand to lose, and with respect to withdrawal, I mean, so does it depend on is it an absolute or relative number with respect to how much of the state budget? Is it a situation where you have to make a calculation about how hard would it be for that state to make up in state tax revenues the federal revenue they would lose? Does that depend on whether it's a high-tax state or a low-tax state? Just seems to me, and then what's the political climate in that state? It seems to me like
in your view, does federalism require that there be a relatively clear line of accountability for political acts?
Yes, of course it does, Justice Kennedy.
Is that subsumed in the coercion test, or is that an independent?
But here the coercion test, as it's been discussed, I think, for example, in Justice O'Connor's dissent in Dole and some of the literature, does address federalism concerns in the sense of the federal government using federal funding in one area to try to get states to act in an area where the federal government may not have Article I authority. But as Your Honor suggested earlier, this is a situation in which, while it is certainly true that the federal government couldn't require the states, as the Chief Justice indicated, to carry out this program, the federal government could, as Your Honor suggested, expand Medicare and do it itself.
But you agree that there still is inherent, implicit in the idea of federalism, necessary for the idea of federalism, that there be a clear line of accountability so the citizen knows that it's the federal or the state government who should be held responsible for their program.
Yeah, certainly, but I think the problem here is...
Does coercion relate to that, or is that
yes, but I think
is that a separate thought?
But I think it relates to it in the opposite way that my friends on the other side would like it to, in that I think their argument is that it would subject us to such a high degree of political accountability at the state level to withdraw ourselves from the program that it's an unpalatable choice for us, and that's where the coercive effect comes from. And that's why I think...
Well, but I think the answer would be that the state wants to preserve its integrity, its identity, its responsibility in the federal system.
And it may, and of course it may do so, and it can make...
May it do so? Doesn't the question come down to this? Maybe you can answer this, yes, but isn't the question simply, is it conceivable to you, as it was evidently not to Congress, that any state would turn down this offer that they can't refuse? Is it conceivable to you that any state would have said no? to this program. Congress didn't think that because some of its other provisions are based on the assumption that every single state will be in this thing. Now, can you conceive of a state saying no? And if you can't, that sounds like coercion.
I think Congress predicted that states would stay in this program. But that prediction is not coercion, and the reason Congress predicted it, I think, Justice Scalia, is because the federal government is paying 90+% of the cost. It increases state costs.
What do you predict? If you predict the same, that 100% of the states will accept it, that sounds like coercion.
Prediction is not coercion. I disagree, Justice Scalia. That's just an assumption, and if it proves to be wrong, then Congress has time to recalibrate. And beyond that, I do think, if I just want to go back to the other part of Your Honor's point, that with respect to the relationship between the Medicaid and the Act, and particularly the minimum coverage provision, my friend Mr. Clement has suggested that you can infer coercion because with respect to the population to which the provision applies, if there's no Medicaid, there's no other way for them to satisfy the requirement. I want to work through that for a minute, if I may, because it's just incorrect. First of all, with respect to anybody at 100% of the poverty line or above, there is an alternative in the statute. It's the exchanges with tax credits and with subsidies to insurance companies. So with respect to that, the part of the population from 100% of poverty to 133% of poverty, the statute actually has an alternative for them. For people below 100% of poverty, it is true that there is no insurance alternative, but by the same token, there is no penalty that is going to be imposed on anybody in that group. To begin with, right now, the level of 100% of poverty is $10,800. The requirement for filing a federal income tax return is $9,500. So anybody below $9,500, no penalty because they don't have to file an income tax return. The sliver of people between $9,500 and $10,800, the question there is, are they going to be able to find health insurance that will cost them less than 8% of their income?
Well, I'm not following this argument. Take the poorest of the poor. If there is no Medicaid program, then they're not going to get health care. Isn't that right?
Yes, that's true. But
so Congress obviously assumed, it thought it was inconceivable that any state would reject this offer because the objective of the Affordable Care Act is to provide near universal care, and Medicaid is the way to provide care for at least the poorest of the poor. So it just didn't occur to them that this was a possibility. Well, when that's the case, how can that not be coercion? Well, unless it's just a gift, unless it's just purely a gift. And it comes back to the question of whether you think it makes a difference that the money, a lot of the money to pay for this is going to come out of the same taxpayers that the states have to tax their money.
These are federal dollars that Congress has offered to the states and said, we're going to make this offer to you, but here's how these dollars need to be spent. This is the essence of Congress's Article I authority under the General Welfare Clause and the Appropriations Clause. This is not some remote contingency in an effort to leverage in that regard. This is how Congress is going to have the federal government's money be used if states choose to accept it. Yes, it was reasonable for Congress to predict in this circumstance that the states were going to take this money because it is an extremely generous offer of funds, 90+% of the funding. States can expand their Medicaid coverage to more than 20% of their population for an increase of only 1%.
If it's such a good deal, why do you care? If it's such a good deal, why do you need the club?
Well,
it's a good deal. Take it. We're not going to. If you don't take it, you're just hurting yourself. But we're not going to.
That's a judgment for Congress to make about how federal funds are going to be used if states choose to accept them. And Congress has made that judgment. That's Congress's judgment to make, and it doesn't mean that it's coercive.
You have another 15 minutes.
At least. But the point is, there's no realistic choice. There's no real choice, and Congress does not, in effect, allow for an opt-out. I mean, we just know that.
Well, I guess
and it's substantial.
I would go back,
Justice Kennedy,
I would go back to the fact that 60% of the Medicaid spending is now optional. It's a result of choices that states have made that has expanded
even
their
though
own
those are now
obligation.
frozen in,
Well, but
per our earlier discussion, to a large extent.
Well, no, to a much more modest extent was my point, Justice Kennedy. For example, optional services, where a huge amount of money is spent, more than $100 billion annually. The largest component of that is nursing home services. That remains optional. It's right now, once the maintenance of effort provision remains in place, states have the flexibility to reduce those numbers. States have considerable flexibility now and going forward with respect to the way that money is spent. And I do think in terms of evaluating whether this expansion should be considered coercive, it's got to be evaluated against the backdrop of the fact that the states are generally taking advantage of the opportunities of this statute to greatly expand the amount of money that the federal government spends and the amount of money that they spend to try to make the lives of their citizens better. I think it's very hard.
Of course, they have to do so by hiring very substantial number of more employees. There will be state employees. There will be substantial state administrative expenses that are not reimbursed.
Well, but I would take issue with that, Justice Kennedy. Part of the Affordable Care Act is that it provides for new streamlined eligibility processes to get people into the system at a much faster and cheaper rate. There are going to be costs to set that up, but under the statute, the federal government is going to pay 90% of those costs, the short-term setup costs, and then all of the projections that we have seen suggest that the medium to long-term costs, once these changes are in place, are going to be dramatically lower for the states on the administrative side.
Obviously, the federal government isn't bound to that. And what if after the 90% they say, well, from now on we're going to pay 70%? What happens then? Where does that extra money come from?
Well, I think then the states would have a choice at that point whether they were going to stay in the program or not. But that isn't what we have here. And they can just bail out whenever the government reduces the amount of the percentage that it's willing to pay. The states can say that's. I'm not saying it would be an easy choice, Mr. Chief Justice.
They'd have to bail out of Medicaid.
States would have to,
not just
right. That would be right. That would be the option. They can leave Medicaid if they decide that isn't working for them. I'm not saying this is an easy choice. I'm also not saying it would happen because the Secretary does have this discretion.
Well, the Secretary has the discretion. We're talking about something else. We're talking about fiscal realities and whether or not the federal government is going to say we need to lower our contribution to Medicaid and leave it up to the states because we want people to be mad at the states when they have to have all these budget cuts to keep it up and not at the federal
But that would be true, Mr. Chief Justice, whether this Medicaid expansion occurred or not.
I know, but you've been emphasizing that the federal government is going to pay 90% of this, 90% of this, and it's not something you can take to the bank because the next day or the next fiscal year they can decide we're going to pay a lot less, and you states are still on the hook because you say it's not an easy choice. We can ask whether it's coercion. You're not going to be able to bail out of Medicaid. You just have to pay more because we're going to pay less.
Well, like I said, I agree that it would be a difficult choice in some circumstances, but that is not to say it's coercion as a legal matter or even as a practical matter, and I think it would depend on what the circumstances were, on how, and I think trying to think about how a court would ever answer the question of whether it was coercive, it was too difficult as a practical matter for states to withdraw.
I'm trying to go back to that because Justice Kennedy asked you whether I think he said, it's coercion if no one can be politically accountable. I'm not sure how that could be, practically politically accountable, because almost every gift, if the terms are attractive, it would be an unattractive political alternative to turn it down. Dole itself was one of those cases. I think every state raised the drinking age to 21, correct?
Yes, Justice Sotomayor, and this argument was raised in Dole, and the Court rejected it as a...
I guess my point is that political accountability has two components. What can I do if I like something, and what can I do if I don't like something? And if people really like something like Medicaid, they're not going to let you drop it, correct?
Well, the citizens of the state, but that's
exactly.
the citizens
that's
of
the
the
whole
state
point. That's
acting
their
in
choice,
their
right?
capacity as citizens of the state, and I think that's what try to get back to the point. That's why I think this is it was wrong to think about this as coercion, because this is a program that works effectively for the citizens of the state, and state governments think that, and that is why it has expanded the way it's expanded, because it's providing an essential service for millions of needy citizens in these states. It's providing access to health care that they would not otherwise have.
You mentioned the Dole case. Now, what was the threat in that case? Raise your drinking age to 21 or what?
Or lose a percentage of your highway funds.
Remember the percentage?
7%, yes.
Now, it's a pretty small amount. That's really apples and oranges when you're talking about lose all of your Medicaid funds or lose, I thought it was 5, but 7% of your highway funds.
I think I agree with Your Honor that it's different, but I don't think that makes this coercion as a legal matter. As I said, I think that this is a situation in which if the states, I'm not saying it would be an easy choice, but the states made the choice. They make the choice.
Well, they made a choice with the stimulus bill, didn't they? Some governors rejected the stimulus bill.
That's
and
correct, Justice Sotomayor.
Some of their congressional or legislative processes overturned that.
That's right.
And others, they supported it. The percentages were smaller, but it's always the preference of the voters as to what they want, isn't it?
What was the threat in the stimulus bill? What would the state lose?
That answer I don't know.
Would anything be taken away, or would it just lose the opportunity to get the money?
I don't know the answer to that. But if I may just say in conclusion that I'd like to take half a step back here, that with this provision, the Medicaid expansion that we're talking about this afternoon, and the provisions we talked about yesterday, we've been talking about them in terms of their effect as measures that solve problems in the economic marketplace that have resulted in millions of people not having health care because they can't afford insurance. There is an important connection, a profound connection between that problem and liberty. And I do think it's important that we not lose sight of that in this population of Medicaid-eligible people who will receive health care that they cannot now afford under this Medicaid expansion, there will be millions of people with chronic conditions like diabetes and heart disease. And as a result of the health care that they will get, they will be unshackled from the disabilities that those diseases put on them and have the opportunity to enjoy the blessings of liberty. And the same thing will be true for a husband whose wife is diagnosed with breast cancer and who won't face the prospect of being forced into bankruptcy to try to get care for his wife and face the risk of having to raise his children alone. And I could multiply example after example after example. In a very fundamental way, this Medicaid expansion, as well as the provisions we discussed yesterday, secure the blessings of liberty. And I think that is important as the Court is considering these issues, that be kept in mind. The Congress struggled with the issue of how to deal with this profound problem of 40 million people without health care for many years. And it made a judgment. And its judgment is one that is, I think, in conformity with what lots of experts thought was the best complex of options to handle this problem. Maybe they were right, maybe they weren't. But this is something about which the people of the United States can deliberate and they vote. And if they think it needs to be changed, they can change it. And I would suggest to the Court, with profound respect for the Court's obligation to ensure that the federal government remains a government of enumerated powers, that this is not a case in any of its aspects that calls that into question, that this is a judgment of policy that democratically accountable branches of this government made by their best lights. And I would urge this Court to respect that judgment and ask that the Affordable Care Act in its entirety be upheld. Thank you.
Thank you, General. Mr. Clement, you have 5 minutes.
Thank you, Mr. Chief Justice, and may it please the Court, just a few points in rebuttal. First of all, we've talked a lot about the sort of hallmark of coercion, your money or your life, with somebody with a gun, I would respectfully suggest that it is equally coercive, certainly not uncoercive, if I say your money or your life, and by the way, I have discretion as to whether or not I will shoot the gun. I don't think that eliminates the coercion. I also don't think this is a discretion that the Secretary would ever be able to exercise. And the reason is we disagree on the details, but the Solicitor General and I agree that over the years, Congress has had different approaches to expanding Medicare. Sometimes, as in 1972, it makes the expansion voluntary. That's also, by the way, what happened with the stimulus funds, which were voluntary funds. You didn't lose all your Medicaid funds, which is why 17 states could say no. Sometimes they take the voluntary approach. Sometimes, as in 1984, they take the mandatory approach. If the Secretary exercised the discretion to say, you know what, it really isn't reasonable for you to have to give up your funding for the visually impaired and the disabled just to cover these newly eligible people, so we'll make it voluntary, we'll make that discretionary, that would essentially be converting a 1984 amendment approach to a 1972 amendment approach. And I just don't think that's the kind of discretion that the Secretary has, with all due respect. Now, moving on to the next point, Justice Alito, your hypothetical, I think, aptly captures the effect on this based on the fact that these tax dollars are being taken from the state's tax base. And it's not like Steward Machine, where the federal government would say, and oh, by the way, if you don't take the option we're giving you, we're going to have a federal substitute that will go in and we'll take care of the unemployed in your state. Here, if you don't take this offer that we're giving you, your tax dollars will fund the other 49 states and you'll get nothing. But, of course, this situation is much more coercive, even than your hypothetical, because it is tied directly to the mandate. It's also tied to the participation in the pre-existing program. So it's as if there was yet another program for post-secondary education. They gave them exactly your option, and then they also said, oh, and by the way, you not only not get these funds, but you'll lose the post-secondary funds as well. It's really hard to understand tying the pre-existing participation in the program as anything other than coercive. The Solicitor General makes a lot of the fact that there are optional benefits under this program. Well, guess what? After the Medicaid expansion, there'll be a lot less opportunity for the states to exercise those options, because one of the things that the expansion does, precisely because the expansion is designed to convert Medicaid into a program that satisfies the requirement of the minimum essential coverage of the individual mandate, things that used to be voluntary will no longer be voluntary. The perfect example is prescription coverage. That's a big part of the benefits that some states, but not all, provide voluntarily now. It will no longer be voluntary after the expansion because the federal government has deemed prescription drugs to be part of the minimal essential health coverage that everybody in this country must have under the mandate. So that option that the state has is being removed by the expansion itself. The Chief Justice made the point.
Ask one question about your bottom line in this case. It sounds to me like everything you said would be to the effect of, if Congress continued to do things on a voluntary basis, so it's adding these new eligibles and say, states, you can have it or not, you can preserve the program as it existed before, you can opt into this. But you're not asking the court as relief to say, well, that's how we cure the constitutional infirmity. We say this has to be on a voluntary basis. Instead, you are arguing that this whole Medicaid, the addition, the whole expansion has to be nullified, and moreover, the entire Health Care Act. Instead of having the easy repair, you say that if we accept your position, everything falls.
Well, Justice Ginsburg, if we can start with the common ground that there's a need for repair because there is a coercion doctrine and this statute is coercion, then we're into the question of remedy. And we do take the position that you describe in the remedy, but we would be certainly happy if we got something here and we got a recognition that the coercion doctrine exists, this is coercive, and we get the remedy that you suggest in the alternative. Let me just finish by saying that I certainly appreciate what the Solicitor General says, that when you support a policy, you think that the policy spreads the blessings of liberty. But I would respectfully suggest that it's a very funny conception of liberty that forces somebody to purchase an insurance policy whether they want it or not. And it's a very strange conception of federalism that says that we can simply give the states an offer that they can't refuse, and through the spending power, which is premised on the notion that Congress can do more because it's voluntary, we can force the states to do whatever we tell them to. That is a direct threat to our federalism. Thank you.
Thank you, Mr. Clement. And thank you, Jennifer Verrilli, Mr. Needler, Mr. Carvin, Mr. Katsas, and in particular, of course, Mr. Long and Mr. Farr. The case is submitted.